Hello everybody, my name is Michael Quinn. I'm one of the directors of the Quinn Group. This week on Quintessential TV, we'll be discussing the Federal Court of Australia providing clarification on the personal services income rules. The Federal Court recently handed down two decisions relating to the Personal Services, PSI as they're known, rules. Income is classified as PSI when more than 50% of the income received under a contract is for a taxpayer's labour, skills or expertise. The PSI rules are integrity provisions which ensure individuals cannot reduce or defer their income tax by income splitting or by diverting income for their personal services through companies, partnerships or trusts. If the rules apply, the individual is taxed on the income directly. The rules do not apply if at least 75% of the individual's PSI is for producing a result, where the individual supplies all the required tools of trade and is liable for rectifying defects in the work. This is known as the results test. In the matter of Douglas and the Federal Commission of Taxation, the Federal Court confirmed that the taxpayer did not meet the results test. The taxpayer argued that the results test is still satisfied even if they do not get paid for achieving a result, provided they can show this is the custom or practice of independent contractors in their industry. The Federal Court rejected this, agreeing with the ATO's earlier determination to apply the PSI laws to tax Mr. Douglas's contract income as his own income, rather than income split through a partnership with his spouse, which also meant that certain other deductions were not allowable. The Federal Court also affirmed the imposition of penalties for recklessness, noting that the tribunal had previously found the taxpayer's failure to include income in his return merited characterisation as gross carelessness and his subjective view as formed from a self-interested misunderstanding of the legislative provisions. In a separate matter of Fortuna Tow and the Federal Commissioner of Taxation, the Federal Court allowed the taxpayer's appeal from an earlier AAT decision that found that he had failed to satisfy the unrelated clients test despite advertising his services on LinkedIn. The Federal Court found the ATO and the AAT had applied an exception from the unrelated clients test where services are provided through intermediaries, for example, recruitment agencies, too broadly, and instead the court preferred a narrow interpretation of the exception. This matter has now been referred back to the AAT to be reconsidered, and the ATO has said that it will consider this decision and whether an appeal is appropriate. If you'd like to know more about the personal services income rules or you need advice in this area, please contact us. You're welcome to email us at info@quinns.com.au. We'd love to get your feedback with relation to Quintessential TV, so please like, comment and subscribe. We look forward to seeing you all again next week. I'm Michael Quinn. Bye for now.